Hello everyone, I'm Maratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, please do support us by liking and subscribing to our YouTube channel. Let's begin. Congress leader Dr. Jaya Thakur has filed a review petition before the Supreme Court of India against the recent judgment in the case of Jahid Abhiyan versus Union of India, which upheld the validity of the 103rd Constitutional Amendment dealing with the 10% reservation for economically weaker sections, popularly known as the EWS reservation. On November 7th, 4 separate judgments were authored with different reasoning by judges of the Constitutional Bench. The plea asserts that even though the forward caste population is only 6%, post the amendment 10% reservation for the EWS to be provided to the poor of the forward caste. We have made a detailed video on this particular development, the link to which has been given in the description box below. Please do check it out. A constitutional bench of the Supreme Court today said that it wants to see the files relating to the recent appointment of Arun Goel, a former bureaucrat, as the election commissioner on Monday, that is on November 21st. The bench, which is hearing petitions seeking an independent mechanism to appoint election commissioners, observed today that it would have been appropriate had the appointment by the centre not been made when the matter was being heard by the Supreme Court. The Supreme Court bench also asked the Attorney General to produce the files tomorrow. During the hearing today, Advocate Prashant Bhushan, appearing on behalf of the petitioner, submitted that Arun Goel was given a voluntary retirement from service on Thursday and that his appointment was notified on November 21st. Chief Justice of India D.Y. Chandrachud today said that the Supreme Court will have specialized benches for hearing criminal appeals, land acquisition cases, motor accident claims, and tax matters from next week. From next week, there would be special benches for old criminal appeals, direct and indirect matters, land acquisition matters, and motor accident claims tribunal matters, CJI Chandrachud today said verbatim when a counsel was mentioning a case for urgent listing. In an important judgment pronounced today, the Supreme Court of India has directed all state electricity regulatory commissions to frame regulations under 181 of the Electricity Act 2003 on the terms and conditions for determination of tariff within a period of 3 months. The court has further directed that while framing these guidelines on the determination of tariff, the Commission shall follow the principles prescribed under Section 61 of the Electricity Act of 2003, which also includes the National Electricity Policy and the National Tariff Policy. Where the state commissions have already framed such regulations, they shall be amended to include provisions for criteria for choosing the modalities to determine the tariff in case they are not included. The Supreme Court has directed the state of Madhya Pradesh to conduct state mop-up round of counselling for NEET-PG courses afresh. The order was passed in a plea alleging that the state of Madhya Pradesh has declared the result of the state mop-up round for admission to postgraduate medical courses before the AIQ mop-up round result was declared. A bench comprising the Chief Justice of India, D.Y. Chandrachud, Justice Hema Kohli and Justice J.B. Pardewala noted that the act of the state of Madhya Pradesh to declare results of state rounds of counselling on November 17th before that of the AIQ rounds, which was declared on November 19th, was contrary to the directions of the Supreme Court. The Supreme Court of India has adjourned the plea moved by former Chief Minister of Uttarakhand, Trivendra Singh Rawat, challenging the High Court order which had directed the Central Bureau of Investigation, that is the CBI, to probe into corruption allegations against them. The Uttarakhand High Court order had directed the CBI to file an FIR and investigate the allegations of corruption levelled against Rawat by an investigative journalist Umesh Sharma. On Tuesday, a division bench comprising Justices M.R. Shah and M.M. Sundaresh was informed that efforts are being made to close the main litigation. During the hearing, senior advocate Kapil Sibal, appearing on behalf of journalist Sharma, made this particular disclosure. The Supreme Court has reserved its judgment on whether, in the absence of evidence of complainant direct or primary evidence of demand of illegal gratification, it is not permissible to draw inferential deduction of culpability or guilt of a public servant under Section 7 and Section 13, Clause 1, Subclause D, read with Section 13, Clause 2 of the Prevention of Corruption Act of 1988, based on another evidence adduced by the prosecution. The Supreme Court bench, comprising Justices Abdul Nazir, B.R. Gawai, A.S. Bopanna, V. Ramasubramaniam and B.V. Nagaratna, was hearing this particular matter. Commenting on the delay in adjudication of cases, the Kerala High Court has recently observed that introspection by the judiciary is also necessary, or otherwise people will lose faith in the system. The court directed its Registrar General and Registrar Judiciary to bring to the Chief Justice's notice the old writ petitions pending in different jurisdictions and take appropriate steps in accordance with his directions. Justice P.V. Kunhi-Krishnan said some of the writ petitions are pending for about 20 years in the High Court and blamed the registry for the sorry state of affairs. The state government has approached the Kerala High Court against the Additional Sessions Court of Trivandrum order dismissing the culpable homicide charges against IS officer Sriram Venkatiraman and his friend Wafa Feroz in the alleged drunk driving case related to the death of journalist K.M. Bashir back in 2009. In the criminal revision petition filed through the concerned additional public prosecutor, it has been stipulated that the statements of the witnesses had revealed that the accused was in an inebriated state at the time of the incident and had been reluctant to give his blood sample with a view to destroy the evidence, and that he had made all possible effort in this regard to delay treatment when he was taken to the General Hospital on the day the accident took place. Thank you. Keep watching Courts Today on LiveLaw for more such updates. If you like our content, it would mean a lot to us if you could like and subscribe to our YouTube channel. See you tomorrow.